Good evening. I'm very happy to be filling in for Bill Hunter tonight. I know that he's very proud of his son, and I'm glad that he was able to attend the ceremony. So I'll be doing the best I can in trying to explain where we've been, where we're at, and where we may be headed. Again, Bob and I duplicated this slide. The only thing I would add to that another purpose that we have is raising funds to be able to pay for attorneys and experts to help us fight this landfill. And we have done an amazing job at that. The public has been just incredible in the amount of donations that they've given, both monetarily and into our garage sales and so forth. But the fight isn't over yet. And so while we will continue to have continuing expenses, we will have to continue some forms of fundraising, and we'll be discussing that later on in the program. To date, we've been able to stop the first Pintail landfill application, and for a lot of different reasons that could really be made into a very good book and movie. A lot of different things have gone on concerning our government officials and violations of the Open Meetings Act, etc. The lawsuit that Cal and the City of Hempstead filed against the county and the outcome of that. And certainly the rather amazing behavior on the part of Green Group Holdings in the spoliation of evidence and how they've conducted themselves in all of this. But ultimately, we were able to defeat it for technical reasons. And it was July 17th of 2015 when we were allowed, after requesting from the administrative law judges in the SOAR contested case hearing, we were allowed site access. And the purpose of that visit that day was to measure the water levels in the piezometers on site. And as you can see, this is a picture. I'm going to go back one here. And in this picture, this is the piezometer, which has a metal casing, as you can see, and it's closed there. And when we drove up to this piezometer, you can see the water was just flowing out of it. When we opened it up, then there's a PVC pipe in the middle with a cap on it, and it has a little vent hole in it, and the water was just spewing straight out about 14 inches into the air. So that was the reason, the basic reason on why we were able to defeat the first application. And the site hadn't changed. It's still a bad site, and we're hopeful that we'll never get into a position again where we'll have to go to those technical issues to fight a landfill application in the future. I think we're in a good path right now and in a good shape. The transfer station is a much easier thing to get because it is a registration and not a permit. And TCEQ was able to get that transfer station registration, which does not allow the public an opportunity for a contested case hearing. We did file a motion to overturn with the executive director at the time that he granted the registration. He denied that motion by operation of law, which means that he took no action on it. We then filed a lawsuit in Travis County against TCEQ, and we unfortunately lost that case in the end. So they do have a registration for a transfer station, which is good probably for another year or so. And if they don't construct one by then they will lose that registration. But the shoe is on the other foot now, because Pintail submitted a second application, it was denied, and now they are in the position that we were in on the transfer station registration. They're the ones who are having to fight with TCEQ over the return of the second application. That's just a little bit of the past. I'll get more to recent events that have happened since our last public meeting, which I think was in November of 2015. Pintail did go ahead and exercise the option to buy the property, so they now own that 723 acres. The deed was signed on June the 6th of 2016 with an effective date of June the 8th. We know because we were able to get a copy of the option agreement, that they paid $9 million for the property. in addition to a royalty to the previous owners of 20 cents per ton of every of all of the trash that will be deposited there if they're ever successful in getting the permit. Then on June the 30th, they filed the second application. And you'll notice that this is actually good. I didn't think this was going to be readable, but they basically did the same thing they did in the first application, which is they only submitted 2 parts of the application. There are a total of 4 parts of an application to make a complete permit application. They submitted parts 1 and 2 only as part of a land use only determination request. Now that does not equate to a permit application, but TCEQ has basically considered it a permit application. We have issue with that. We never got that far to be able to argue that in court because the first application was returned. But in any event, they did the same thing here. So they submitted parts 1 and 2. The second application, again, is what parts 1 and 2 is considered a bifurcated application, which is a land use only determination only. Within that second application, they included a memorandum, and this memorandum was an explanation to TCEQ on why they felt that the City of Hempstead and the Waller County ordinances did not apply to them. Parts 1 and 2 contain no technical details of the design of the landfill itself, but it does give the basics of it. And the basics that they described the landfill as was a much bigger and more dangerous landfill than what the original one was. This is a table showing the comparison between the first landfill and the second landfill. The actual permitted area, which is the permit boundary area, not the landfill footprint itself, they decreased from 410 to 405 acres. And they did that so that the entire permit boundary area would fit within the ETJ of the City of Hempstead. So it wouldn't be part in the ETJ and part within the unincorporated area of the county. The disposal unit area itself, which is the size of the landfill footprint itself, is identical between the first and the second permits. The buffer in other areas, which they had planned on putting up berms and planting some trees and so forth, that area is decreased by 5 acres because they've got 5 acres less in the permit boundary. The total permitted capacity, the comparison between the original one was 35.67 million cubic yards in its lifetime. The second one was increased to 55. That's an increase of 19.3 million cubic yards. The total operating lifetime of the landfill was increased from 49 years to 67 years. That's 18 years longer. The maximum elevation of the landfill, they increased by 95 feet from an elevation above sea level of 410 to 505. And then they're not only made it taller, but they're going deeper into the water table. We already know, and the reason the first application was returned is because it was discovered that it would have been under the water table. That's not necessarily against state law to do that, but they didn't have all of the parts in their application in the first application that would allow them to do it, and it was returned. So they're going basically 23 feet deeper into the water table with this second application. So it's a much worse thing. It's almost as if they're being vindictive to us to come and make such drastic changes to what they're asking for. The next thing that happened, if you remember back on October 25th, the TCEQ held a public meeting at the Hempstead High School auditorium. Approximately 350 to 400 citizens attended. Senator Lois Kolkhorst attended. She made powerful arguments against the TCEQ proceeding with processing the application. Representative Cecil Bell also had a representative who read a letter stating his determination to protect our aquifers. Pintail explained that they did not yet know what the technical design of the landfill would be, but that they were working on it. In order to be able to design a landfill that goes into the water table, then it's a very complicated thing to do technically, because they have to use dewatering techniques in order to keep the excavations that they're digging from filling in with water. And the amount of water that they would have to withdraw to be able to do that and build the liner is rather large, because it's a very prolific aquifer. It can supply a lot of water, and it poses problems to them as far as what are they going to do with that water. They would be using these dewatering techniques to the point where they can build a landfill, get enough trash in it, so that it would hold, or the water would keep from attempting to lift the bottom of the landfill. And then they'd stop pumping water, and the water table would come back up and engulf the entire bottom of the landfill. And they would be doing that in stages. They also explained that they had hired a series of consultants and new attorneys. John Riley is now the attorney that's representing them in this case. The previous one was Brent Ryan, and if any of y'all went to any of those public meetings at the high school, you probably remember Brent Ryan quite well. And then they responded to questions about the departure of a lot of other Pintail and Green Group Holdings top executives. Oscar Allen, Ernest Kaufman, they're no longer with them. Also during this time period, the public responded with another record number of public comments being submitted. In a very short period of time, that's roughly 2 to 3 months, a total of over 3,000 public comment letters were sent into TCEQ over that short period of time. In addition to that, Kelvin was collecting comment letters from Prairie View A&M students, and those were submitted a little bit later on.
The Student Government Association.
Bob said it was the Student Government Association that was collecting the letters. Kelvin got them and mailed them into TCEQ, but at that point in time, TCEQ had already returned the application, so none of those letters actually got posted on their website. But I'm told that there was over 2,500 letters from Prairie View and A&M students. Wow. Also, all of the prior parties to the first contested case hearing filed briefs with the TCEQ saying why they should not process this application because of the ordinances and so forth. Then, on December the 1st, it took TCEQ a while, but they studied it closely and they did make the decision to return the application. And they basically said that since the City of Hempstead's and Waller County's ordinances prohibiting landfills in the proposed location were adopted before Pintail filed the application, the Commission may not grant Pintail's application. And then they cite the section of the Health and Safety Code that gives the counties and municipalities the authority to pass such ordinances. So, obviously Pintail didn't like that, so they filed a motion to overturn, an MTO, it's commonly called. A motion to overturn is requesting that the executive director's decision be overturned. It's an appeal to the full 3-member TCEQ board, and it's the 3-member commission that has the final say on all permitting matters. There is a deadline to file an MTO, and that deadline is 23 days from an action of the executive director. Once an MTO is filed, the TCEQ can place it on a commission agenda for a ruling by the 3-member commission, or they can do nothing and deny it by operation of law. The deadline for the TCEQ to take action on that is 45 days. And if they take no action on it within 45 days of the executive director's decision, then it's automatically denied by operation of law. Now, the commission has the ability to extend that deadline up to 90 days. And that's exactly what they did. On December the 30th, the TCEQ extended the 45-day deadline for the Commission to take action until February 17th, last Friday. They also set a schedule allowing that the Office of Public Interest Counsel for the TCEQ and that the Executive Director himself filed briefs to the Commission. They had until January 13th to do that. Then Pintel was given until January 27th to respond to any of those briefs that the TCEQ received. And again, OPIC and the Executive Director did that. But in addition, the City of Hempstead filed a response to the MTO, and then CALH and Waller County filed a joint response to that MTO. And then on January 27th, Pintel did file a response to all of our replies. Now, in addition, the Texas Water Code, under Chapter 5, which relates to the TCEQ, allows for judicial review of TCEQ actions. It basically allows for lawsuits to be filed directly against the TCEQ in Travis County District Court to appeal the action of the TCEQ. Such lawsuits must be filed within 30 days. And Pintel did, within 30 days of the return of the application, file a lawsuit directly against TCEQ in Travis County. Now, what are Pintel's arguments? Pintel is making a lot of different arguments on why the ordinances don't apply to them. They center around the ordinances that they're either not valid for a variety of reasons or that Pintel is grandfathered from them for a variety of different reasons. All of their arguments are ones that they have raised with the TCEQ before. Many of them they actually raised before they filed a second application, and for which the TCEQ legal staff has already studied them extensively and had already rejected them. Some of their arguments claim that the City of Hempstead ordinance prohibits landfills anywhere within the entirety of the city limits, their extraterritorial jurisdiction, the ETJ, and beyond, and is therefore invalid. And that the county ordinance couldn't apply to the Rainy Ranch site because their first application, which is we call Pintel 1, was pending for the site at the time that the ordinance was passed. Well, the argument there is that it was only parts 1 and 2, and we take issue with the fact that it's called a landfill permit application because it wasn't. It was a land use only determination request. But in any event, they're saying that that was a snapshot in time, since there was an application pending when the ordinance was passed, that it doesn't matter what happens to that application, that site is forever then allowed to have applications for a landfill submitted. And obviously we disagree with that, and so did the TCEQ. In other arguments, they claim that likewise the city ordinance couldn't apply to them because the city ordinance passed their ordinance on September the 8th of 2015. Now, that was before the TCEQ returned the first application. The first application was returned on October the 5th. And so they're claiming that a permit application was pending at the time that the city ordinance was passed. Well, again, that's essentially the same snapshot in time argument which our attorneys and the city's attorneys and the county attorneys and the TCEQ attorneys don't agree with. They also claim that they were grandfathered from both ordinances because they do have a transfer station registration application that was submitted before either of the two ordinances were passed. And so they're claiming that even though a transfer station is a registration, not an application, it is still an other authorization under Chapter 361. Well, the TCEQ has already given its opinion on that, and that is that a transfer station is substantially enough different from a landfill that the transfer station registration does not grandfather them. So TCEQ has already issued their opinion on that. They also claim that both ordinances are invalid because they don't describe the areas where landfills either are or are not permitted by specific metes and bounds. And there's actually nothing within the Health and Safety Code that requires you to spell out specific metes and bounds for these areas. But that's one of the arguments that they're making. Again, all of those arguments were studied in detail by the various TCEQ legal staff for a 5-month period of time or longer, and were rejected and resulted in the return of the second application. Now we'll get to a little bit more current stuff that, if you've been following along on our Facebook page and website and so forth, some of you may know some of this, some of it may be new to y'all. Well, you probably do know by now that it appears as if the TCEQ did deny their motion to overturn. As I said, the deadline was last Friday, the 17th, and we can find no action anywhere that the TCEQ took any action whatsoever on it. And our attorneys feel comfortable that they did not take action, and as a result, it was denied by operation of law. Now, I mentioned that Pintel filed a lawsuit against the TCEQ on the executive director's decision. We fully expect that Pintel will likely file a second lawsuit against TCEQ in Travis County for the denial of their motion to overturn. And what will happen is they'll probably consolidate those two lawsuits in the future. But as of now, there is no pending application for a landfill at the Rainey Ranch.
All right.
Now, should Pintel be successful in Travis County, then the TCEQ would likely be directed to continue processing the application. We don't feel like they have a very good chance of being successful in Travis County. They're basically throwing everything they can at the problem to save any chance at getting a landfill permit here. But if they lose in Travis County, then the TCEQ could actually appeal that. And whether the TCEQ would or not, we don't know. But they certainly would have the opportunity to. Now, if Pintel loses in Travis County, then obviously they could and probably would appeal that decision as well. Travis County District Court has historically recognized TCEQ's discretion in interpreting the rules and statutes that apply to the TCEQ. The TCEQ has made its position known on the second application. The arguments that Pintel is putting forward, well, anything can happen in a court of law, but Travis County does have a history of backing up the TCEQ in its decisions, as witnessed by our experience with the transfer station registration, which I think we had good arguments on. Ultimately, it's expected that the issue of the validity of the two ordinances will eventually come to Waller County District Court. Waller County District Court is really the proper legal venue for determining the validity of these local ordinances. These are ordinances passed by local government entities, and they are presumed by law to be valid. If the county or city passes an ordinance, you have to obey it. If you disagree with it, if you don't think it's legal, or if you don't think it's valid, then you have an opportunity to challenge that. But you have to take them to court in Waller County, or whatever the county is where that ordinance was passed. And so I think ultimately, depending on what happens in Travis County in their lawsuit against the TCEQ, it's quite possible, if they don't just pack it in and give up, and they haven't shown any indication that they're going to do that yet, it will probably end up in Waller County District Court. So again, any judgment in Waller County could also be appealed, and it would be appealed to one of two appeals courts in Houston. And again, whichever side loses could very easily appeal. So in any event, it's in the courts now, and all of these legal actions could end up taking a considerable amount of time. Now, we will need to continue our fundraising efforts, because CALH's attorneys are very good attorneys, and they follow this stuff. They keep us up to date on what's going on. They are ready to provide guidance to us and what we should or should not do and they are ready at a moment's notice to spring into action at our direction. So anytime, if and when it's needed, they will be there, and it is quite likely that we will continue to use our attorneys in future court cases. The amount of funds that will be needed is unknown at this time. Litigation gets to be very expensive. We're not in any litigation now. Whether we get into litigation in the near future or not is really unknown at this point. But we're not ready to throw in the towel. We're not going anywhere. We're not giving up the fight. But we are going to need to continue to do fundraising so that we can continue to utilize our attorneys. Final thoughts. We're in a much better position now than we've ever been since we first found out about the proposed landfill in June of 2011. We've never been in as good a shape. But we must and will, with your help, remain strong and vigilant until the day when Pintail and Green Group leave Waller County for good. So that's a summary of the legal situation. I'm going to talk very briefly. As y'all know, the 85th legislature is in session. Naira Miller is representing Cecil Bell. It was a very nice letter that he wrote. My understanding is that he is working on some legislation and has reached out to us for some ideas from us, which we'll be doing in the future, and the same with Senator Colcourse. Senator Colcourse has already filed Senate Bill 551. Now, she filed that on January the 20th. It was referred to the Natural Resources and Economic Development Committee on February the 8th. The caption of that bill is relating to inaccurate or incomplete permit applications for solid waste facilities. And basically what it says is that if you get an application that's so bad that you have to return it because it's either incomplete or inaccurate, that you as TCEQ have the right to return a second application from them if it's not perfect, if it has any inaccuracies or incompleteness. So it basically puts a number on the bites of the apple, at the apple, that an applicant can make on a landfill application. And it would have been very beneficial to us had that been, if this bill had been in place before they submitted the second application. In addition, Senator Judith Zaffarini filed a bill, Senate Bill 781. It was referred to the Agricultural, Water, and Rural Affairs Committee yesterday. It has to do with relating to a limitation on the location of solid waste landfills. Now, this bill unfortunately doesn't do anything to help us. It has restrictions on it. It basically has to do with placing landfills over recharge zones of certain aquifers. But the way the bill is written, it is specifically geared towards a different landfill that has a pending application, and that is the Post Oak Clean Green landfill in Guadalupe County near Seguin. So I mention this to let you know that there are other bills out there and you know, as we go through the legislature, these bills can be amended and so forth, but this particular bill is not likely to help us at all. And then there are a number of other bills. As I said before, Cecil Bell is working on one bill. We're going to be having discussions with Senator Colcourse as well on some other ideas on some bills. I believe the deadline to file bills is in March the 20th, is it?
I believe so.
Yeah, March the 20th. So we've got a little bit of time, but not a whole lot. Okay, and as Bob promised, I want to give you a little bit of update on some other Green Group landfills, because y'all might find this interesting. Y'all have probably heard of the Arrowhead landfill in Uniontown, Alabama. It was originally permitted as a municipal solid waste landfill, very similar to the Pintail landfill. And then there was a coal ash spill in Tennessee. That was a major natural disaster, and they had to clean it up and take it somewhere. And the EPA and various others decided to send it to that Arrowhead landfill in Uniontown. People in Uniontown is a very small, very poor black community, and they have been very active in being very vocal and being very upset about the effects of all of that coal ash being deposited in that landfill. They have suffered tremendous problems because of all of that coal ash. Well, back in, I believe it was probably April, maybe a little before then, last year, Green Group got fed up with them complaining, and they filed a $30 million lawsuit against basically 4 principals of the organization out there that's opposed to the Arrowhead landfill. $30 million, and these people are poor people living mostly in trailer homes adjacent to the landfill. The name of their organization is Black Belt Citizens Fighting for Health and Justice, and they sued them for libel and slander in relation to what they were saying and claiming about the Arrowhead landfill. Now, the ACLU, the American Civil Liberties Union, took up those citizens' defense, and they went nationwide in publicizing that lawsuit. I don't know how many of y'all had heard about that lawsuit, but they agreed to defend them in court. And like I say, that was all began early last year. Well, just very recently, on February the 6th, Green Group Holdings agreed to a settlement with the Black Belt citizens to drop the lawsuit. And they agreed to drop it and dismiss the lawsuit with prejudice, which means that at no time in the future can they come back and refile that lawsuit against these people. Now, in return, the Black Belt citizens gave up their right to countersue for defamation or malicious prosecution, but at least they were able to reach an agreement that was satisfactory, and they have that no longer hanging over their heads. And I think that really, you know, that lawsuit was filed before Ernest Kaufman left, and because of the amount of publicity that I got, I don't know this, but I suspect that probably had something to do with Ernest Kaufman leaving, but that's pure speculation on my part. Now, Green Group Holdings filed an application in Caldwell County for a landfill which they call the 130 Environmental Park. They recently, in August, had a 2-week-long contested case hearing. And as you know, we never got to that point because it was returned before we got to the actual hearing on the merits. But since that time, once the contested case hearing happens, then the administrative law judges allow each of the parties to file closing arguments, written closing arguments. And then each of the parties has a chance to respond to those closing arguments by the other parties. And so it takes a while for all of that to happen, for the administrative law judges to go through all that stuff, and then come up with what's called a proposal for a decision, which is their basically their ruling. Well, it was also on February the 17th, last Friday, the administrative law judges did issue a proposal for decision on that case. And unfortunately, they recommended that the TCEQ issue that permit in Caldwell County with three very minor modifications to the permit. Now, again, once the proposal for decision, the PFD, is issued, then all of the parties have a chance to file exceptions and briefs on what they find wrong with the proposal for decision. So all of the parties will be filing briefings. The deadline to file initial exceptions is March the 9th. Once all of those are submitted, then the other parties can respond to those exceptions, and the deadline for that is March the 20th. And so once all of that happens, then the administrative law judges can either amend their proposal for decision, taking into consideration the various arguments that were made, or they can just send it on to the TCEQ commissioners, who will put it on their agenda and then make the final determination to issue the permit or not. So it's not a happy situation for the people in Caldwell County, and we feel very badly for them. But the process is not over, and it would probably be towards the middle or third quarter of this year before it ever gets before the commissioners. So there's still quite a bit of legal wrangling to be done over there. Then there's another landfill that is not a part of Green Group Holdings, but it's in Guadalupe County near Seguin. I mentioned it earlier. It's called Poso Clean Green. They had their contested case hearing. The ALJs issued a proposal for decision. During the process when they were filing exceptions to that and so forth, the U.S. Air Force stepped forward. They were apparently unaware of this application. And they have a nearby training base there where they train pilots in T-38 jets. And part of the approach to this training base is right over or very close to where this landfill is proposed to be. And they took exception to that and said, now wait a minute, we've got issues with the safety of our jets, because typically on the approach to this training base, they are typically 2,000 to 3,000 feet, which is not all that far above a landfill. So there was some new evidence that was issued back and forth in it, and the administrative law judges eventually issued a revised proposal for decision, recommending either that the application be denied or that it be remanded back to the TCEQ to make changes to the application, operating hours, that sort of thing. Well, it appears as if the ALJs were ready to send all of the documentation, all of the records and everything back to the TCEQ. But in that revised proposal for decision, they talk about a communication that they came across between the Air Force and the applicant and the TCEQ. And apparently the Air Force got together with the applicant, made an agreement on changes to operating hours and so forth, and came up with a memorandum of understanding and issued it to the TCEQ without sending it to the SOAR court. SOAR court found out about it. They mentioned it in their proposal for decision and probably had an effect on their change in the proposal. But in any event, that's improper. That's called ex parte communication, because the SOAR court was aware of communications that were happening outside of this, and it didn't allow the protestants in that case to be able to respond to that memorandum of understanding. So it's rather an interesting legal situation there. It's going to be a really interesting one to watch, which is the only reason I mention it. So basically, that's all I have right now. I'm going to turn it back to Bob, and he's going to go over some of the fundraising issues that we have and what we'll be doing in the future. And so we'll have a question and answer session afterwards. So, thank you.